Today, I'm here with Alston Macon of the Law Offices of Jeff Palmer. He is an expert in probate. Today, we're going to, from a high level, discuss the ins and outs of selling your home when a loved one has passed on. So, without further ado, we'll bring it over to Alston. So, Alston, thank you for meeting with me today.
Absolutely.
And we just want to go over the probate process. I know there's a lot of people out there that don't fully understand the probate process. They don't know what an executor is. They don't know what happens when somebody dies and they don't have a will and they have a house that the house is in disrepair and maybe they're out of state or whatever. So there's a lot of challenges to overcome when a loved one passes away and you inherit a house. So could you kind of explain to us about the overall process in a nutshell?
Okay, when somebody passes away, the property they own still belongs to them.
Right.
And so it has to be transferred through the probate process, unless there's a survivorship deed and it passes outside of probate. They have to open up an estate for an individual. And so if the individual does not have a will, they have to open up what's called an administration with the county. And the judge is appointed over the case, and he oversees the administrator, who has to be an Alabama resident in order to serve. There's a bond required.
Okay, so the administrator has to be a resident of the state where it's open.
Yes, to serve as the administrator.
Oh,
sometimes families out of state will have an attorney fill in for that role, or have somebody else, a distant relative or somebody appointed to help out with the situation.
Okay. So what if they don't have any family in that state?
It would probably be best to have an attorney serve as your administrator.
Okay, so you can do that.
Yes, absolutely.
Okay. What is it called when an attorney serves as the administrator?
It's the same thing.
Same thing. Yep. Okay, so no difference. And I've been told, I don't know if this is true or not, but it's like the first family member to get to the courthouse and is the administrator.
Technically, it is.
Okay.
If anybody can open up an administration. Someone that's not related could open up one, but it's the first person to get there that can open up the administration will get the letters immediately.
Okay, what letters are you talking about here?
The letters of administration.
The letters of administration. Okay.
That's what appoints that individual over the estate.
Okay.
So the process basically happens is you file a petition with the court to have that individual appointed, and then if you have property that needs to be sold, in an administration you have to have court approval.
Okay.
Because there's no will to determine what the person wanted with their property. The law determines that.
So is this approval just to sell it, or is there approval of the price or all of that?
It's an approval of everything.
Of everything.
Yes, it's the price, it's the condition, it's whether it's in the best interest of the estate. In an administration, because there's not a will, the court oversees, the state oversees the administration of the estate to make sure it's handled properly. That's why they require a bond over the personal property. But when you have a piece of property, you've got to make a motion to sell the property. You've got to provide the contract. You've got to provide photos and then the tax worksheet to say what the value the county has found for it. And then most of the time in administrations, you'll get the other heirs to sign a waiver saying that they're agreeing to the price, they're agreeing to the sale, so that the court may not have to have a proceeding. Otherwise, if those aren't filed, there will be a hearing set by the judge, and he will determine, taking evidence and things, as whether it's in the best interest of the estate.
Okay.
After that process, whether there's a hearing or not, he will issue an order that allows the party to then sell, so they can sit down at the closing table and get the transaction done.
Okay. So the judge approves the property to be sold. Then when the offers come in, does the judge also have to approve?
It would have already come in.
Oh, okay.
In order to go to the judge to seek approval, you have to have a contract.
I got you.
And the contract will always be executed with the seller as the estate. Okay. Even if an individual, thinks that they may have already inherited the property, they need to be listed as the estate. So that's always going to be the seller.
Okay. Very good. And just so we're clear here, we're in the state of Alabama, and we're discussing the laws of the state of Alabama. So the laws could potentially be different in another state.
Yes, and they are.
they are. We can't all get on board with the same way of doing things in this country. So that's funny. Okay, so I know something that I've run into from buying houses is, say there is an executor, right? And so I'd like for you to get into that whole executor process, because we were just discussing when someone dies intestate, right?
Yes.
Which means intestate means when you die without a will. So even if there is an executor, I know sometimes there's a 6-month wait period, and
Well, all estates have to remain open for a minimum of 6 months in Alabama in order for creditors to file any claims against the decedent or the estate.
Okay.
So that's the minimum time it has to be open.
okay,
So any funds that were received from the sale of a property would have to be held in the estate account for that 6-month period at a minimum before they could be distributed.
right. And the main reason they do that is so if there's any creditors out there
Yes, that they'll be satisfied.
right. Okay. Very good. Okay. So at what point should somebody, get in touch with an attorney then? Is it immediately or when they're getting ready to sell? Or I would think it'd be in your best interest to get it immediately so that 6 month, well, I guess the 6-month clock probably doesn't happen until the day you open.
Yeah.
So it's in your best interest then to get with you immediately, right?
Absolutely. It would always be in people's best interest to open up an estate right away, depending on the circumstances. But, people are limited by their own their situation. So sometimes it's not economically, where they can do it. But yes, absolutely, you should get ahead of the process because a lot of people that come to me have gone to go try to sell the property that they don't own yet because it hasn't been probated.
Oh, wow.
So they end up back with me, and then they have to start the process all over again. Negotiating, and then closing is not going to happen until we get that order. So it pushes things back. So you got to be aware of that with probate real estate, is that there will be some court delays in that process. So,
what are some of the misnomers out there that I know you've talked to a lot of people who've gone through the probate process. What are some of the things that you've heard that people hear, like, I heard that, and that are just not true, that let's try to clear the air here on that?
Well, the main one I run into is that it's heir property, that somehow it's passed to the heirs without anything happening, without having a probate proceeding. And a lot of times people are confused about the process, or they're worried about how much it's going to cost. And so those are usually the main things that I run into.
Okay. And an heir is, what's the definition of an heir? Just in case somebody may not know what that means.
Well, basically, it's a descendant or a devotee of the person. Okay. So it could be a natural born child of the person. It could be someone that was adopted by the person. Or if you have a will, you could have devotees. You could have people that you name in the will to receive something that may not be related to you. So they would still be an heir under the will.
Okay. So there's an instance where there's a 92-year-old lady. Her parents have been passed away for about 30 plus years. Okay. And the parents were on the deed. And a neighbor wants to buy this house. And the house is currently vacant. She had some renters, bad situation, got them out. But now the house is vacant. There's maybe no family members around, right? So how does she go about selling the property in that situation?
Well, it would depend first on the deed that the parents held. If there was survivorship and one of them passed before the other, it would pass automatically to them by law. And so then you would be able to determine which of those individuals you would need to open up an estate for. So you would need to make the process simple. You would open up an administration for that individual and then ask the court for permission to sell the property.
Okay, so that's great. Now, here's another scenario. So this guy buys a property from a tax sale.
Okay.
And because the taxes are past due.
Okay.
And the people that owned the house before that, they're passed away, no relatives or anything like that. So he buys what's a tax deed, right? Or, well, actually it's a tax certificate, right? Okay. You buy the tax certificate, and then a couple years later, you can, I don't know the whole legal system, but
I do.
You do. You do. And maybe you can elaborate a little bit more, and then it turns into like a tax deed. And then, so this guy has this tax deed. Well, he thinks he has a deed, but he doesn't really have a general warranty deed.
Yeah. And
maybe you can elaborate on that as well. But then, we get down to, okay, now he wants to sell that house to me. Mm-hmm. And for me to be able to get a warranty deed on that, it's a long process. So anybody that's in a similar situation, how would they handle that? Because I think there's some probate issues along those wrapped up in that as well, right?
Potentially, yes. In Alabama, if you don't pay your property taxes by December the 31st, in May or June of the next year,
Right.
the county will go on the courthouse steps and sell a certificate for the taxes. It's not the property itself, it's just the taxes. And so those taxes, that certificate is either purchased by an individual or a company, or if nobody buys it, then the state of Alabama pays for it and holds it at the state. And so after two things, one of which is if the date from the certificate, the original certificate, is 3 years from that date for the individual to redeem through the county, which is called statutory redemption.
Okay.
Once that 3-year period passes, if someone has held the certificate, they can apply for what's called a tax deed.
Right.
It's not a deed to the property, but it gives you the right to the taxes and also possession. So you can go into the property.
So you can't go into the property before you get the tax deed?
You can. When you buy a certificate in Alabama, you have to give the owner a 6-month notice before you can file an action. That's not to say in 6 months I'm coming in, 6 months before I can file a legal action to get you out. That's a prerequisite. That's required by law. If you do not do that and you go in and you start working on the property, you will not recover.
Okay. So that 6 month period, you have to give them notice, and then from there, there's what's called an ejectment. Is that right?
Yes. An ejectment is different from an eviction, where an ejectment is simple. I have the right to this property. You don't. You're occupying it. Get out. That's how simple an ejectment is. So yes, you would file an ejectment action to remove either the owner, the previous owner of the home, or somebody that it was squatting, or somebody that they had rented out to, or something like that. So you would eject whoever was in the property. Because when you have the tax deed, you have to have the tax deed for 3 years and have possession of the property, which means you're taking care of it. You either live in it, or you have a renter in it, or you've maintained it to where it can be habitable. And once you do that, you can file an action called quiet title.
Right.
And so after that, after the certificate changes to the tax deed, the individual that owned the property has 3 more years to redeem through what's called judicial redemption. So they have to come directly to you as the party and ask you what you've done to the property. The things that are allowable under Alabama law, if you purchase a certificate and you go in and you do work on the home to preserve it and maybe rent it out, or if you eject somebody, with a tax deed and say, hey, I'm taking possession of this, I'm going to put work into this property. What you're entitled to under Alabama law to recover is the amount of the taxes that were paid, the value of preservation improvements. Doesn't mean just what you spent to remodel or to get the home ready. It means what value was added by those items.
Okay.
And then insurance that you had to put on the property while you maintained it. And then 12% interest on that amount before January of this year, 8% if you purchase one after January of this year. So you get
January of 2020?
Yes.
January of 2020, after you purchase the property, it goes to 8% interest, which is a big deal. It's a lot of buzz about that recently.
And that's a very serious process under the law. When somebody contacts you to redeem, you have 10 days to respond in writing as to what you're claiming, and they have 10 days to respond back to you after that, whether they agree or they're going to name a referee. So there's a process that you engage in to resolve the matters about the value of the improvements, not the other items. The taxes and the insurance and all those other things are cleared, interest. But that's what the process is. The redemption process is over. So you have a referee appointed, and then the other side has to appoint a referee within 10 days. Again, they meet and they try to decide what the value is together. And if they can't, it gets kicked to another sport. It's an umpire takes over, and they try to make a final decision. Most of the time, though, what I see is that the referees, when they can't agree, we just end up usually in litigation. So we go to probate court to argue over the redemption issue and have the court determine what the value of the property.
So I'm sure the word you were just using there was not a legal term. Is that right? Is that a legal term?
Which
when you
one?
Said the referee?
Yes,
that is a legal term. Okay.
Yes, that's the process that you engage in, and that's what the statute lays out. Alabama law lays all of it out.
So I think it's also important to reiterate, though, once you take possession of that property, say the counters tops are in a mess, right? So you take them out and you go and you put high-end marble tile and granite and all that stuff. That complicates things, does it not?
That would not be a wise decision.
Right.
You want to maintain the property in a habitable condition where you could rent it out. So you want to put basic materials that would they would comport with that home and then the neighborhood and whatever, so you wouldn't want to overbuild
Right.
or put too much into a property. So that would absolutely be.
What could happen if you overbuild, put too much into the property?
Well, the process for redemption that I was just mentioning, the referee process, they try to determine the value of the improvements. If you've improved it beyond what the value is, then you're probably going to be limited to what you can recover. And so if you don't go through that process or you fail to meet some of those deadlines, if somebody comes to you and asks you what you're claiming and you don't respond, they get to go redeem. If you respond and say, I'm claiming this amount, and they don't respond back and disagree, you get what you asked for by law. So there's no leeway there. Now, there have been a lot of cases that have come out, especially recently, on some of these issues, on redemption issues. And so the law is a little bit, there's a little bit of uncertainty in it right now, but that's the basic process that you go through. And then, as I was mentioning earlier, once you have a tax deed, the date of the tax deed, 3 years from that date, you can then file, if you have possession as well, you either got to eject or have possession. For 3 years, you can quiet the title. So that's an action in Alabama Circuit Court where you basically provide the tax deed, you state how long you've had it, and that you're entitled to basically quiet the title, which is to resolve any issues about that property and the ownership. Okay. So if there are any old mortgages that haven't been resolved, if there are any liens, if there's anything hanging over the property, that would be when you deal with it in court. So you would name all of the people in the chain of title for the last 10 years. You would look for any of those issues with mortgages. Sometimes I have quiet titles where there was a mortgage 20 years ago. Right. It probably was satisfied, but nobody ever filed anything. Right. So you've got to get it cleared up. Yeah. So that's one of the ways to do that. But it really just wraps up the whole thing for that property. And then once the judge issues an order in your favor, it's recorded like a deed would be. Sure. And so then that gives you clear title. Okay. So when the title company, if you go to sell that property, the title insurance company will see that and know that the title has been cleared. Right.
So somebody that's wanting to buy this property is going to want typically going to want a general warranty deed. So you have to go through this process.
Well, it depends.
Yeah.
I have transactions where people will sell tax deeds to other people.
Right.
And then they'll quiet the title. It just depends on what's best for the parties.
Right.
If it's in their interest, if they want to spend the money to do it before they sell it, or if the buyer requires it. And sometimes people can't wait, right. So it's something you really need to be aware of in these situations in order to make it, go as efficiently as possible.
But if you sell the tax deed,
mm-hmm.
the rights to collect the interest and the repairs transfers as well, correct?
Yes. Okay. And the period of time that they possessed it. So you add on, if you purchase a tax deed from somebody else, you can add on the time they possess the property to your 3 years. So you can make up, if somebody had it for 2.5 years, you only have 6 months left to wait.
So it could be a pretty good business then to go and buy a tax deed.
Well, it's certainly, something you need to have qualified people, assisting you with.
For sure.
Most of my clients are investors in property, and they come from everyday walks of life, from all areas, and they want to change their lives. They want to invest in property. They want to be their own boss. They want to eventually get to a point where they work for themselves.
Absolutely.
And it happens every day. That's the majority of the people I work with are those kind of people. So.
Absolutely. And, my wife and I are investors as well. And I could, scenarios keep flooding my mind around this whole probate process. And, one potential property that we were going to purchase, it would have been a good purchase for us. The house was in bad shape. The foundation needed a lot of work. I think the quote we got was like $20,000 to fix this foundation.
Mm-hmm.
Bad mold. They had a brand new baby in this environment. It was really sad. The owner of the house passed away, and the property was left to the son. And the son was letting his daughter and her family live in the house.
Yeah.
They wanted to sell the house, get the money, and actually, I actually referred them to you. Now that I think about it, this was the one where without saying too much, it's the Price residence, and it came down to a matter of cost of why they couldn't do it, because they had to. One of the heirs was a minor,
mm-hmm.
and when there's a minor, so backing up a little bit, so. The guy and I think it was his brother or sister, I can't remember the exact specifics, but a sibling was in this situation. One of the siblings passed away. So the rights, heirship rights, pass to the minor child. So that complicates things a lot too. So can you go into why that complicates things?
Yes, if there's a minor involved in an estate, the court is going to appoint what's called a guardian ad litem over the interests of that person. It's an attorney that's not related to any of the parties, that's appointed directly by the court, that's tasked with looking into the best interests of that child. And so they interview the child, they talk to the family, they make decisions about what's best for that individual's rights in the case. And so that person is appointed by the court. That's part of what you pay for in the probate process, is to have that service when there's a minor involved.
Yeah. Is that an expensive process? Like, what are the kind of costs that you run into? I mean, I guess you have your costs, right? And then there's some other costs that go along with it as well, right?
Well, absolutely. The guardian ad litem is an attorney who will charge an hourly rate in order to perform their duties, looking into the best interest of the child. And so that'll be included by the court at a later time in a bill.
So the court appoints the guardian ad litem.
Yes, the court.
So you have no say in that.
No, and the parents, they work with the parents as well in that situation if there's people to work with, and to make sure that everything's in the best interest of the child. So, but that happens in every case where there's a minor involved.
Yeah. Earlier we discussed the quiet title process. One thing I meant to ask was what's the process timeline on quieting a title?
Well, I'm always hesitant to give definite timelines because the court system, and especially with what we've had going on this year, it's been very difficult to anticipate how things are going to go. But I would say that you're looking at about a 9-month process.
Okay.
If you're lucky, it can go a little bit faster, but it may take longer.
Yep.
So, but basically what you do is you file the complaint. You try to find anybody that you can in the chain of title, and then when you try to get service on some people are passed away. So you have to name them, but then name any heirs or devisees. So you have to do a search to try to find anybody you can that's related to them. Then you provide that information to the court. If you can't find someone, you provide the information to the court and ask for them to do what's called notice by publication. So the court will then allow you to publish in the local publication a notice to the public that this property was in dispute. And so that has to run for 4 weeks in that publication. And then any individual in the world has 30 days after that date to answer or to show up in the case, just like a party would in the case where you get sued and you answer. Anybody could come. If nobody shows up, which a lot of times that's the case, what we do is we make a motion for default judgment. That's where we've told the court we've served everyone. They didn't answer within the legal period of time, so we're entitled to what we're asking for to go ahead and give us a judgment. During this entire process, there's also a guardian ad litem appointed for the interests of anybody that's not there. So to make sure, and the court is just trying to make sure that we're taking property, from somebody to putting it with somebody else. And so they want to make sure that the process is done right. So the guardian ad litem in those situations is appointed by the court as an attorney and does research to back up what we're saying. So they look through the history of the title. They look at the information I've provided. They try to contact anybody they can find that might have attachment to the property. And then they eventually provide a report to the court. And the court uses that report along with our evidence and along with testimony to say, I'm going to issue a final order in this case. Now, if someone showed up in an action on the other side, if it's been more than 3 years and there's a tax deed, there's really not a whole lot they can do. But I've had some parties, where there was somebody that had a mortgage years ago. They may, actually get served with something, but then they don't ever show up. So.
So in quieting the whole quiet title action, does that actually wipe the slate clean, clear? Like, what if there were other liens against that property, like a fire dues lien, which is actually an actual thing that's happened to me recently. So this guy's quieting the title that I'm trying to buy the property. There were some fire due liens on the property. Does that quiet those as well?
Yes, you would need to address those within that case. And that does happen, but it's very important to be thorough when you're dealing with a property issue, especially with quiet title. that you know exactly what is, you have a full title report done in order to determine what has been recorded against this property. Now, I'm sure there's some things that, you know, people never record, but they don't count. So, but if anything's recorded, it's going to show up on the title report, and then I provide that to the court and to the guardian ad litem to show them the history of the property as well.
I'd say probably a few months ago, we were getting ready to buy a property, and we're heading down the path, and title came back. Jeff said, Philip, there's a mortgage recorded on this from a long time ago, several years.
Yeah.
The guy who took out the mortgage had passed on. We're getting ready to buy this house, and the closing attorney from this office, he called him and said, Phil, there's this mortgage recorded from several years ago. And I'm talking to the seller, and I said, ma'am, you know, there's a mortgage. She said, well, that was from my dad. He's deceased. The mortgage company that had the mortgage is no longer in existence. Yeah.
I've run into that.
It was mind blowing. So the mortgage company is no longer in existence. They apparently sold to some company, and we've contacted all these companies. They cannot find record of it.
Yeah.
So then again, in that situation, you have to go through the quiet title action, correct?
Yes.
I found that there's no other way around that one.
There isn't, because you've got to clear that issue up to be able to sell the property and transfer it properly. It's something that has to be handled. Those situations I run into are where a lot of times it's where a bank, they were paid off for the mortgage and they never filed a release.
Oh, I've run into that too.
Now they're supposed to, by law, required to do so within a certain period of time, but that usually doesn't happen at all. And so what we'll do is we'll try to reach out to the bank, or in the case, I had a recent one where the bank had been sold to a large bank years ago, and you know, I don't even know if they still had any records. It took a 2-month process to get them to send me a release. They recorded it and sent it to me. And there's other situations where I have quiet titles right now where, like you said, there was a loan. Both the gentlemen that took the loan out are dead. And so there's nobody there to satisfy or to file anything. And the lender, you know, it was a private individual, and they're not there either. So we had to name those individuals in the quiet title action in order to have the court clear that issue up and to say there may have been a mortgage at one time, but there's no reason, you know, it's not hanging over the property anymore.
Okay. Yeah, that actually happened to me too on another property. This guy was selling a couple of properties, and this one particular one in the portfolio, there was a mortgage, and he paid it off. He sent me bank records. Like, look, here's the bank record. I think it was like a $20,000 mortgage, and it was like with a private individual, so it wasn't even with a bank.
Yeah.
And the private individual, I guess, failed to record the mortgage. And that individual was with this particular company, and there was bad blood through the partners, and it dissolved, and this guy was unwilling to cooperate. So the house is still sitting.
Yeah.
So when someone loses a loved one and there is property involved, is it wise for them to maybe do some sort of like preliminary title search, just kind of see what's hanging out there? What do we have to tackle? Because I know sometimes, often, it happens more than I like, that the attorney that I'm closing with comes back, whether it be you or Jeff or whoever here, comes back and says, oh, there's these probate issues. And they're big issues.
Yeah.
And so now time is wasted, hopes are up. People are like, they think they're going to get this money. They started making plans for what they're going to do with this money, and it just can't close.
Yeah.
A lot of times it's because maybe they can't afford to pay attorney fees. Yeah. And attorneys, you know, do a great service for us. And what they do, it's not, you know, it's affordable, but not to everybody. You know, some people are just not in an economic situation where they can afford this kind of things.
Yeah.
So, you know, I guess my advice to them would probably be, you know, I'm not a big fan of credit card debt, but get a credit card, put it on the credit card. Do you guys accept credit cards here?
We do. We accept several forms of payment.
Okay.
I would say that if you get close to the point where the family wants to deal with the property, it's when I would start looking into it. I wouldn't just do a title report after somebody passes away. But if there is a property, you know, and that's one of the problems I run into, is that I end up with the person after they've already gone to try to sell the property. They didn't come beforehand.
Yeah.
So they're in a situation where they've got to get it resolved. And then, you know, everybody involved is looking at what the time period is. You know, why is it taking this long? You know, we got to get this property closed, but we have to go through the probate process. And I don't feel comfortable setting anything until that order comes in, to be honest with you. Yeah. So that's the most important thing you have to have in order to close.
Gotcha. Do you think that there's too many people that go without wills?
Well, not necessarily. It just depends on their person's situation. You know, like you said, it depends on their economic ability. But it's always best to plan out what's going to happen. Right. You know, if you can, with the will probate process, different from the administration process. Basically, the individual has executed a document that determines where they want their property to go, and so the state respects that, and the court is not required to supervise that. Now, the will to be valid, the will has to be what's called self-proving. It has to have certain requirements. The witnesses have to testify that the person was of sound mind and 19 years of age. He has to sign that as well, and then the notary has to sign that both of the witnesses sign. And if the will is valid, then the court will admit it without any supervision. Most wills have provisions for allowing you, the executor, to sell property, to handle any kind of issues with the property. In the event that the will does not have that provision, then we do have to ask the court for permission to sell the property, just like we would in administration. A will is different in the sense that you file it in probate. The person that's appointed as the executor under the will immediately gets appointed. Okay. So they get issues letters of testamentary, and if the will contains the power to sell, they could sell the property at any time after that. Once they have those letters of executorship, they can basically sign the documents to close the property. So that'd be, if there's a will in place, it's always a good idea to have a will if you can. And it depends on how much stuff you have. Sure. If you don't have a lot of stuff, there's really not a whole lot to worry about. Yep. But it's a way for you to determine what you want to happen with the things you've worked for, as opposed to just allowing, you know, the law to determine that. Sure. And under administration, without a will, the law determines where your property goes. Okay. If you're married, your wife, of course, inherits everything. If you're married and you have children, your wife gets the first $50,000 of your property, and then the remainder is split between the wife and the children. Okay. So there's a lot of different, you know, and if you pass without any children or wife, your brothers and sisters may inherit your property. Or if you die and you could just have parents, they wouldn't inherit your property under the law. So the law determines how your property goes. If you don't have a will, the will determines how your property goes. So.
And you guys do wills here, right?
Yes.
Okay, awesome. All right, so Austin, I appreciate your time today and going over this process. I know it's a very difficult process, and I know a lot of times it's tough because people are grieving at the time they've lost a loved one, and there's property involved, and you know there's a lot of bills to pay when someone passes on, and so sometimes liquidating a property is helpful to them to be able to pay all these bills that have come due.
Well, one of the largest misconceptions is that the administrator or the executor has some sort of personal liability. Mm-hmm. People are concerned about getting involved in the estate sometimes because they may have to pay the bills or something. Right. Well, that's not actually the case. So there's no personal liability for that individual other than if they did something improper.
So you think that keeps people from opening up the estate? I believe it does
sometimes, yes.
Oh, wow.
And I've heard that from people who ended up later opening estates that said that. And the fact is you have no personal liability for the estate. You have to manage it in the best interest of the people, and the court's going to be looking over your shoulder in the case of administration, but that's your responsibility. Okay. You know, so. Well,
that's good to know. I mean, because I think I've heard that before, and you know, I've never had to deal with a loved one passing on and dealing with their property or their estate, so that's good to know.
Well, you have to determine if there's any creditors that file claims. You have to address those. You have to determine what is in the estate, if there's bank accounts, if there's property, stocks, you know, any kind of personal items, all that stuff. Right. And so your job as the administrator executor is to manage the process of that. You don't have any personal liability, and if there's not enough there to pay the bills or to pay the mortgage, then you have to decide what the best action is, and that's to work something out with the bank for a short sale or to find a buyer for the property, you know, so.
Good deal. Well, if somebody wanted to reach out to you to ask you about helping them open up an estate, how would they contact you?
They can contact our offices here, the offices of Jeff W. Palmer, at 205-871-1440, and we'd be happy to talk to them.
Okay, great. Yeah, and if you're interested in selling your property, maybe it needs a lot of work, we can close within as little as 10 days. We pay cash, we close very fast, we pay all the closing costs, and we work with really awesome attorneys like Austin here. And we are a solution provider. This is not just a real estate business to us. We feel like we are helping people. We're helping them provide solutions, and we wanted you to be informed about all the things you need to consider when someone passes away in your family and there's a property to deal with. So if it's a burden to you, we would love to help you get rid of that burden and buy your property. You can reach us by going to www.ibuyhomesfastforcash.com and fill out a form. We'll get back in touch with you and see how we can help you with your property. Thank you and God bless.